If you're just thinking about, well, if I tell the police this and I'm good for right now, you're not thinking about exactly all the different, the consequences of speaking to them about these different things, which is why I'm very much against people talking to the police in general. So yeah, chess is analogous, very analogous to what we do. I'm gonna put this on silent here so we don't get interrupted as often.
Ben, do you have any microphones for us, or are you going to use the audio on there?
This one will catch up everything.
Cool. Yeah, those Esteban is crazy detailed.
Yeah.
Cool. So how you doing, man? Before we kick this off.
I'm great, bro.
Yeah.
Yeah, just crazy busy, which is not something to complain about, but it keeps you, keeps you sharp.
It
doesn't result in much sleep, but
who needs sleep?
Yeah.
When you die.
Sleep is overrated.
Yeah, sleep faster, as Arnold says. Is all you do is self-defense cases?
Predominantly.
Nice.
Yeah, predominantly.
That's a lot of lives.
It's not exclusive, but you'd think that, if it was just me, then, it'd be just exclusive, but, it's a firm, so there's a lot involved. We do a lot of injury cases, which people don't know, and we make a lot of money on injury cases because they're easy revenue generators.
Really?
Oh yeah. It's a car crash, so it's a car crash, a truck crash, or a medical malpractice, or a wrongful death. God forbid, because you don't wish it on anybody. But those cases there's only so much time that you're actually investing.
Yeah.
Into those cases.
Yeah.
It's really a lot of paperwork and a lot of phone calls and not a lot of litigation and getting in the courtroom and swinging. In these cases, I'm sorry, it's pretty cold, and I'm wondering why they actually left that fan on. I don't even know how the hell to control it. But these particular cases that we're talking about, self-defense cases, are very time intense.
Yeah.
So you get wrapped up in these cases and you can spend a lot of time, and they can be very lucrative because we get paid for our time. So the case I finished in California recently, probably just south of $500,000 was invested in that case. And that's a grandmother who is defending herself against 3 young adults. One is 17, the others are 20 and 21. 20, yeah.
And she shot him?
Both 20. She shot like the 20-year-old. I think he was 20. She shot him in his chest, and he lived.
That's crazy.
And we tried that case, and we had a hung jury the first time. It was very difficult. Anyway, I'm getting off on a tangent, but yeah, there's a lot of procedural nuances from state to state. Can you cut that? What are you smiling about?
Because I didn't know if we were recording.
No, yeah, you can cut. It's all good. Yeah.
I was trying to get back here before they started recording.
No. I don't need the lights cut. I need the fan cut. Yeah.
My house has wiring like that where I'll flip one switch and the food dispenser comes on or something. Yeah.
I love that.
Cool. I'm also going to live stream this too, just heads up.
All right. It's going down. Yeah. Thanks. So we could talk about that case, or we could talk about some general, some specifics.
So
on what it is.
No, you're good.
No, you're all good. Yeah, don't stress. So I've got a couple of questions. So I started like this training group, and so I asked them, I was like, hey, if you guys have any questions, let me know. And then so a couple of them shot me some questions, and then also kind of the most common things that I've been getting asked a lot during the legalities portion of the training. Figured hit you with a couple of those, dive into them, so then that way, because one of the biggest problems I have with trainers, well, aside from their lack of real world experience, and they act like they have a lot of real world experience, is that they're very opinionated in the sense of legalities. Okay. So they'll tell you, well, you can't shoot a person who's in your home illegally unless you verify that they have a weapon and they're coming at you threatening X, Y, or Z. And I'm reading the law and I'm like, I don't know if that's true, because the law doesn't say you need to verify they have a weapon. You need to verify that they're a threat. All it says is that you could intervene against a felony in the home. And so that's like one of the questions I got for you is like, give me an example of what that means in legal term, like break it down for me. Marine, really simple, eat crayons. But at the same time, then maybe throw some of your experience in there as well. So that way people have like a definitive answer of, hey, or as definitive as it can be on something like home defense or using self-defense that's likely to cause death or great bodily harm, things like that.
All right, so a couple of different things at the outset, because I don't know where your viewership comes from and who tunes in, to get information. But states obviously differ in terms of self-defense laws. So we have different jurisdictions, with different positions as it pertains to self-defense. So a general rule is just as you just said. If you're using lethal force to defend yourself, you have to. The question is, would a reasonable person believe that he or she is about to receive great bodily harm or death? So I'm going to ultimately dumb everything down, because I like speaking in simple terms, because I would want to understand this if I have a firearm, and I want to educate people with firearms, law-abiding citizens. But I want to start there. So you're talking about lethal force. The question is, for the standard to use lethal force, the question is, it's all about this great bodily harm or death, and the biggest word in the sentence I just gave is reasonable. So it's what's reasonable, when you're talking about self-defense with lethal force, what is in fact reasonable? So there's a serious issue with that particular term, because it's seemingly an objective term, right? When you say reasonable, it's seemingly objective, because generally speaking, when you talk about reasonable, you're talking about what would an average Joe or Jane perceive this situation to be, when you're talking about reasonable. Yet it goes from subjective, because you're the one being attacked, and subjectively how you perceive the situation is obviously going to have great significance. So it goes from subjective, you're being attacked, subjectively, what are you thinking? Not what somebody else would be thinking, not what a group of other people be thinking if you polled them, because that's objective. But subjective, what are you thinking when you're being attacked? It goes from subjective to objective, because now you're on trial, and the question is, was it objective for you to have this belief?
From
reasonable.
From the jury.
Was it objective?
Yeah.
But then ultimately it becomes subjective again, because as you just said, from the jury or from the judge, whoever fact finder is. So whether you try the case in front of a judge, you try the case in front of a jury, it's subjective, because those people are now saying what they believe to be reasonable. So it's really not truly reasonable. Would suggest that it's just something that, what would you take 10 different people and you put them in this position, would they believe that they're about to be, that they're being attacked, they're about to be, they're about to receive great bodily harm or death? Okay.
How do you convey that perspective to the judge,
the fact finder?
the jury? Yeah, like how do you do that?
That's a completely different. That's. We can get to that as well. So I want to just finish with this particular issue right now. We're talking about lethal force. We're talking about the different jurisdictions, because before we could talk about conveying that to a judge or a jury, you have to talk about the jurisdiction which you're attempting to convey that, because different jurisdictions require different things.
So jurisdiction, do you mean state or municipality? Both?
So it's a great question. For jurisdiction, for this, in this context, when I talk about jurisdiction, I mean a state, because every state has their own set of rules, and they apply throughout the state. However, in Illinois, for example, for purposes of jurisdiction, when you're arguing it, you have to understand the difference between arguing something like this in front of a jury or a judge in Cook County in Chicago versus arguing this in front of a judge down south, in a far more conservative, gun-friendly type of county, gun-friendly type of environment, because there's a big difference there. But so there's so many different levels, there's so many different layers to this onion, okay? What's happening right now is you first have to decide, you have to first determine the common denominator, which is lethal force, and what's required to be able to use lethal force to defend yourself, which is what we just discussed. Would a reasonable person believe that he or she is about to receive great bodily harm or death? Now, something else to be said, which is also lost in the weeds very often, is the significance of brandishing a firearm, okay, which is what's usually referred to as brandishing a firearm. But in Illinois, it's called aggravated assault with a deadly weapon, which sounds far uglier than it actually is, but aggravated assault with a deadly weapon. There's some states when you talk about assault that basically implies that you used your firearm. There's some states where you talk about assault, it implies that you're using your firearm to intimidate somebody, to make them, to have them believing that you're about to do something with your firearm, which arguably is closer to the real definition of assault. But again, I don't want to belabor any particular, tangential issue. Here's what's happening. If you use your firearm to threaten somebody, to get back, to thwart, to try to ward off an attack. You use your firearm and you show them your firearm and you say, look, you keep coming here, I'm going to shoot you. That is, once you show your firearm, in Illinois, that's aggravated assault with a deadly weapon. In many other states, it's called brandishing. I have a trial that I was just in down in Vero Beach, Florida, where that's called improper exhibition of a firearm. So it's got a different name wherever you go. But if you use it, that is not deadly force. That is not lethal force. If you use it to show somebody and to warn them.
Yeah.
So there's a lot of people, judges included, that believe that using your firearm in that particular manner is using lethal force, and it's not. So that's something else that has to be understood when we're talking about use of lethal force in self-defense, because brandishing a firearm is not in itself lethal force, or does not in any way rise to the level of lethal force or use of lethal force.
Right.
So there's also a certain ignorance that surrounds firearms as well, just in general. And there are a lot of people, a lot of people in 2A community are saying, hey, if you're going to show your firearm, you got to be prepared to use it anyway. So don't show your firearm unless you're basically, getting your firearm out to actually use it. But there are people
to use it is one thing, but some people will say, oh, if I pull it, I'm using it.
I got to use it.
Okay,
a lot of people say that if you see my firearm, it's because I'm shooting you.
Right. Yeah.
And that's unfortunate that seems to be a very common position, because it can get you in a lot of trouble.
I agree.
It can get you in a lot of trouble very quickly. It's just basically it's removing a certain level of discretion.
Yeah.
And it's inviting a certain amount of criticism from the fact finder, from the judge, from the jury. Why'd you do that? So getting back to what I was saying. Because in the very beginning, this could be a little bit difficult to follow. So I'm trying to come back, circular conversation skills, trying to come back to where I'm at right now, just so I can just have everybody understand this. You have different jurisdictions. So again, for purposes of this conversation, different states that have a duty retreat. You have certain states that have what's called castle doctrine. You have certain states which have a stand your ground law. Okay, and then you have a lot of confusion surrounding what these different types of philosophies are, these different types of laws are, and that confusion, crazy enough, bleeds into the legal community. So even amongst police, amongst firearm instructors, amongst attorneys, amongst judges, there's very often there's misconceptions amongst the people that are teaching this, amongst the people that are judging, amongst the people that are charging. There are these misconceptions. So it's very important to understand what jurisdiction you're in and how that affects everything. Again, before going into answering some of these questions. So duty to retreat, I'm sure is you have an affirmative obligation to get the hell out of there. Mm-hmm. Okay, that's the most basic way of defining duty to retreat. So before you try to defend yourself, you have to try to remove yourself from this particular threat. And there's a lot of criticism surrounding duty to retreat, this particular law, these particular jurisdictions, this particular view when it comes to self-defense, but it very much exists. You have castle doctrine, which very often just, as a general rule, it's grounded in old English law dating back hundreds of years, where basically a man's castle, a woman's castle, home is his or her castle. It's where you should be able to go ahead and defend yourself. And there's a heightened, I guess, argument for a heightened, sense of self-defense if in fact somebody's broken into your home, which basically it's something that you were asking me in the very beginning, which we're going to address in a minute. But, basically, it's not going to be questioned as much if you're defending yourself in your own residence because somebody came into your residence and is threatening you in your residence in whatever particular manner. So that's castle doctrine. Castle doctrine can extend to your business. It can extend to where you're sleeping that night. If you're you could be in a hotel room and you could potentially have a castle doctrine argument. It can also extend to your vehicle. In certain states, it extends to your vehicle. In Illinois, it doesn't extend to your vehicle, but in certain states, it extends to your vehicle as well. So you're in your vehicle, you're being attacked. You have the absolute right to be able to defend yourself. Arguably, there's going to be a heightened, sense of fear because you are in the place that is basically safe. I use the analogy of there's a tag game, where there's a goal where there's home base, and everybody runs out and they're being chased, and you can run to home base and you can touch home base, and nobody can tag you when you're on home base. You're safe.
Yeah.
And that's kind of what the castle doctrine mentality really originates from. So there are a lot of different expansions on what is actually covered and what's not covered, and there's a lot of arguments in that way, and there's no true definition of, hey, if they cross this particular line, that constitutes that's in fact a time that you can automatically just defend yourself, and everything before that you don't really have the right to defend yourself in your home. There's no line that exists in that way. There's no clear definition in that respect. So
really?
No, there isn't. There are certain things which clearly, if somebody's in your house uninvited, they just broke in and they're shooting at you, or they're threatening you with a knife. There's clearly certain things where you can basically across the board say, hey, this is justified because you're in your home and they did this. But there's nothing really very concrete when it comes to castle doctrine. And then the third thing that I brought up is the stand your ground law. Okay. Which became very popular with Trayvon Martin case and everything else down in Florida. Florida got a lot of attention for that, and then there's a lot of criticism from different people as to the significance of stand your ground, and the fact that stand your ground shouldn't exist. This particular type of mentality shouldn't exist. But that's what stand your ground law is. You basically, in a sense, just the quickest, the dumbed down version is, you have the right to stand your ground and defend yourself without retreating. So you can't have a duty to retreat and a stand your ground law in the same jurisdiction, okay? Because they're in direct conflict with one another.
Right,
you can't say you have a duty to retreat, but yet you can stand your ground, okay? So that will not work. That will not fly. So you have to understand the significance. You have to understand the significance of what jurisdiction you're in before getting involved in anything. And then a lot of people with stand your ground law don't necessarily understand, a lot of people with stand your ground laws. Hold on a second. I don't know how difficult it is to. Sorry about that. A lot of people with stand your ground laws don't even understand that they actually have stand your ground law in their particular jurisdiction. So, what I do when I meet with different people for the very first time, and I'm giving some sort of lecture in a particular area in front of a particular community or group of individuals, I often start off by asking, what jurisdiction are you in? Do you know what jurisdiction you're in? Because a lot of people might think that they're in stand your ground law and they actually are duty to retreat, or vice versa. Or a lot of people have common misconceptions concerning castle doctrine. You can actually have castle doctrine and have duty to retreat in your jurisdiction. You can also have castle doctrine and have stand your ground law in that jurisdiction. So it's not, when I ask people what it is, I say it's not a trick question. You can potentially have one, you can potentially have two. You cannot have three, because again, duty to retreat and stand your ground law are opposite one another. So you start off there. You'd be surprised, and I know, I've met, I couldn't even begin to count how many firearms instructors, and I appreciate that so many people take this job very seriously, and that they really want to be a voice in these particular areas, and they want to educate people. You're right. There's a lot of it's scary when you're hearing different different people define certain laws or define what you can and can't do, and they don't necessarily have any background in doing it. But I think there are, as a general rule, the guys that I meet, the men and women that I meet that are firearm instructors, have their hearts in the right place. Sometimes it's just you just kind of have to go ahead and provide them with a little bit more information and education, because it's not uncommon to see firearm instructors providing incorrect information, which is unfortunate.